Good morning. My name is Jonathan Briggs. I'm the assistant law librarian here at Fort Bend County Law Library. Now that we have at least one other participant, Ms. Foster, we'll get started since we got plenty to cover and only about 39 minutes or so to cover it. So I'll kind of go, we got one more in, hold on one second. So now we got Mr. Perkins is now with us as well. Good morning. So this is Courthouse 102, and we're going to get right into it. This is kind of a continuation. Both of y'all were in the class last week, Courthouse 101, and this is a continuation of that class. Gets into a little more detail. So I'm going to I'll email you, of course, this PowerPoint a little later on today. So let me kind of jump in and get going on the PowerPoint and discuss what we have to discuss. Some of the things is similar to the last PowerPoint, a lot of the prefatory material here in the PowerPoint. I'll kind of jump through it. I talked about the law library last week, our establishment of the law library and what our function is, that we're not here to give legal advice, but we're here to help people handle their own legal affairs, and we're here to help attorneys with their cases as well, and provide legal resources in the form of information, be it statutes, anything in the books or on our legal databases. And obviously we provide services here as well. We have computers and printers and so forth. Obviously things are a little bit different given the current health crisis. So we're not fully open, but and I'll talk about that in just a minute. So let's kind of go through and get started on the Courthouse 102 material. This is a continuation where we get into a little more detail. Courthouse 101 sort of talked about the introduction to the courthouse, to civil litigation, to sort of the opening stages of a case of becoming involved in a lawsuit, either by filing a lawsuit or being brought into one, or be as a defendant or a respondent or an interested party in, say, a estate and probate matter, something like that. So it was kind of an introduction in that part of civil litigation. Now we're going to get into a little more detail. Obviously, this is geared towards pro se folks, but it can, if any lawyers are on, then it's, I think, of interest to them as well. So what is litigation? Now you're in a case. It's going on, the case, you've filed a case or you've answered a case, you've made an appearance. What goes on in a case? Obviously down the road, you're ultimately heading towards a trial or at least some type of final hearing, let's say maybe in a family law case or a probate matter. Obviously there can be trials there as well. Civil litigation, personal injury suit or something like that, those are definitely, you're looking towards a trial as the end point, but there's a lot of different steps that can happen before that. There's sort of some nomenclature that we'll get you familiar with. There's discovery, takes up a large portion of civil litigation, at least in my experience. Trial, usually it can vary from court to court, but a fairly sort of a standard deal would be a case takes about a year to get to trial. Let's say you file your case, it'd probably be about a year. It could be less, could be more, and different courts do things differently. Some courts will set your case for trial almost immediately. So say you file in July of 2020, the court might go ahead and set your case for trial in July of 2021. Other courts require you to specifically seek a trial setting and trial date. So it just depends on the court you're in. Obviously, I talked about in the last course, always look on your court's website for information about their procedures, about how they do things. It's very important to do that. There's lots of things you need to know to handle your own case, and that's what we're going to talk about today. And one of them is familiarize yourself with your court's procedures. That's a crucial thing. When I was practicing law, that's one of the first things I did. I got a copy of the court's local rules and their procedures, and I had a binder for every case, and I put that information right up front and tells you how to do things. That way you're not stepping on your own toes and doing things improperly, and you're going to navigate the process much better. So what's going on as you're getting ready for trial? What's the why the lag time? Why the year or several months before you go to trial? Because there's things to do. Some cases are more active or more detailed than others. Some cases are massively extensive. But let's just talk about the context really of maybe a personal injury lawsuit or something else. What are you going to be doing in that meantime? What are the steps? And these steps aren't, 1, 2, 3, 4, you finish one and go to the other. Some of them, there's some overlap between those steps. So discovery is simply what it says. You're discovering information about the case. You're obtaining information from the other side, and there's mechanisms in which you can do that. There's what's called written discovery. You can send out written questions and requests to the other side, asking them to answer questions, asking them to provide documents and other things that are relevant to exploring the case and putting on your case. Let's say I'm a defendant. I'm getting sued by someone who is sued me for a car wreck case. They, say I ran into them and they're suing me for that. And they're saying they were physically injured by that and, underwent medical care for that. One of the things I'm going to do is obtain their medical records. It's an option to do if you want to explore their medical history and their particular medical care in relationship to the claims in the case. So that goes on. There's depositions can occur. That's, sitting down, taking a deposition of a fact witness or of a party under oath. Maybe you'll take the plaintiff in that case. They're suing me for, the car wreck. Maybe my attorney would question them and ask them questions relevant to the case, what they did, their injuries, all those sorts of things, the damages they're claiming. Then there's things such as hearings and motion practice. So while the case is going on, there might be issues that come up that need to be resolved by the court. One thing, it kind of ties in here with discovery. Say I send some questions to the other side and they don't want to respond appropriately pursuant to the rules. And maybe I'll have to bring them into court and say, court, make them respond. And they have the right to do that. Obviously, most cases, just like in the criminal case world, most cases end up being resolved prior to trial. In the criminal cases, people take plea bargains or maybe they get dismissed. Same thing similarly in civil litigation. A lot of cases get resolved beforehand without going to trial. It's probably the majority of cases in some way, shape, or form where you make a settlement with the other side. Say like you're suing you're claiming $100,000 in damages, and maybe ultimately you decide to settle the case for $50,000, something like that. So there's mechanisms in which to try and do that. There's sort of more formal things such as mediation, where the two parties use an intermediary to assist them in coming to a settlement agreement. Or you can just do sort of informal settlement agreements between the parties and negotiations to do that. If those seem to be like they're not going to be successful, you might go forward with hearings and so forth leading up to trial. There's some hearings that might have to be had to discuss certain issues. Hold on one second, I'll make sure. Okay, there's nobody waiting. There might be pretrial hearings on various issues leading up to trial. There's going to be things that you're going to need to file with the court and serve on the other side in advance of trial in a timely manner. There's the trial itself. There's a whole mechanism to that. There's then things can occur after trial. And like I said, this course is pretty, there's no way to teach all this in depth. It's to kind of apprise you of these various things, just to give you some knowledge. So, like I said, this is the focus of this course is somewhat of you're a party to the case. Now what? How do you even do all this sort of stuff? I mean, lawyers go to law school for 3 years, and that's just the beginning of their education as far as how they go about being a lawyer and doing their job. And so pro se folks are sort of dumped in at the deep end. If you're truly going to proceed with your case and put your best foot forward, there's plenty of things you might end up needing to know to do so. So it's kind of a where do we go from here? What do I do now? I'm here in the case. What do I do now? And that's, like I said, we have a lot of resources that will help you with the what do I do now part of it. It's pretty daunting. There's the devil's in the details oftentimes, and the lawyers are a little more familiar with all these details. And this course is kind of designed with a mind that maybe the other side, you're going up against somebody who has an attorney. And in general, not that you don't have wherewithal or intelligence, but you're going up against somebody who at least knows the details about things. Knows what they, as I will say, you'll see in this slide that at the end, but I'll kind of talk about it now. Is I had a law professor who said, "You don't know what you don't know." So how do you even, you have no experience in this. How do you even know what you need to know? And this is a sort of a trying to give you a little bit of a heads up on some of the things you don't know that might come into play here. And you don't know these things, and it's not out of ignorance. It's just, why would you ever know them? It's just like, why would you know about a certain medical procedure unless you're, facing it? And then you do your research on that. So this course doesn't concern criminal cases. Criminal practice, you're pretty much covered. You either hire your own attorney or one gets appointed for you if you can't afford one. Unfortunately, that does not exist generally on the civil side of things. If you can't afford a lawyer, you're kind of on your own. Some people like it that way, but some people are dealing with it simply because they have to. You're trying to put your best foot forward. I would remind you, if you do get sued for certain things, say all of a sudden one day a process server or a deputy comes and knocks on your door and gives you a lawsuit, you've been sued for a car wreck, or somebody injured themselves at your home, the UPS guy tripped on your front walk. Don't forget, you probably generally have homeowners insurance or auto insurance as you're required to. Make sure when you get sued, report that to your carrier. And typically, pursuant to your policy, you're covered. They're required to provide you a defense and indemnity payment for covered events. So, as I said on the last thing, and I won't belabor the point, take care of what you got to take care of. You got to respond to legal papers. You have to be active and proactive. You got to take care of things, as painful as it may be and time-consuming as if you don't do these things, you're probably going to lose, or you're going to maybe have a unfavorable outcome at the very least. So you gotta, if you're stuck with representing yourself or choose to represent yourself, you gotta do your best, and yeah, simple as that. So that's why we're here. We're here to help as much as possible. We're a place. Even though I know the current thing, we're not currently open, but we're typically a place where you can come physically and work, and use our resources. Even though we're pretty much closed, for the most part, we can still provide you assistance in the form of information. I can send you stuff. I can send you forms. I can send you statutes. I can send you information. So there's a lot to know. So you're going to be a lawyer. What all the things that lawyers deal with? What are all the things that you're going to be expected to abide by and know? In court, there's laws, there's rules, there's procedures. There's procedures that are dictated by the state, the rules of civil procedure. There's procedures for each court, how they do things, protocols. Proper formatting of legal documents. We kind of talked about it in the last one. How do you construct a basic motion, pleadings and so forth. There's objections if you're going to trial. What are some proper objections to things? What is the rules of evidence? How do you get evidence into court? How do you basically get items into what is called evidence so that the jury or the finder of fact, if it's the court, can consider them? That's a very important step. Maybe in some respects, I would maybe say the most important. How do you get your evidence in? Because that is what the jury or the judge is going to decide the case on. And how do you overcome objections from the other side? And we'll talk about it a little bit more. There's some things you might want to bring into evidence: photographs, medical records, bank records, things of that nature that could be very important that the people making the decisions need to know about. So you can't just say, hey, here's the bank records, I'm going to set them on the desk and boom, they're in. No, they are not. You have to do things a certain way to get them to be legally cognizable as evidence in a case. So there's all these different things: the rules of civil procedure, the rules of evidence. And, the rules of civil procedure, there's literally hundreds of rules about the minutia of things, of just how a civil case, what are the rules governing it, how you do things. The rules of evidence, you've all heard, watching, Matlock or Law and Order, you hear the objection, hearsay and stuff. That's part of the rules of evidence. There's the rules of evidence and there's cases construing the rules of evidence. So there's all kinds of things. There's things that are hearsay. There's things that are accepted from the hearsay rule. There's things that, though they sound like they'd be hearsay, are not hearsay. It's just there's things you need to know and things you need to be aware of. The Civil Practice and Remedies Code contains several things that are important to civil litigation, such as the rules of venue and the rules of governing the statute of limitations, amongst other things. There's a thing called the pattern jury charges. When the finder of fact, the jury, is going to consider your case, what they're given is called a jury charge. Some of y'all have served on a jury, you know what I'm talking about. It's basically questions that are presented to the jury that they answer, and those answers will be how they render their verdict. So say in a typical negligence case, you would look at, the question would be, what persons, if any, were negligent in this case? And, they give you the definition of negligence and so forth. And so you put two people down, the plaintiff and the defendant. And then you say, if you answered yes to this question, was anybody negligent? Then you got to apprise negligence by a percentage. What percentage of negligence did the plaintiff have? What percentage of negligence did the defendant have? And how those questions are answered will determine what the verdict is. Ultimately, you'll get down to damages. If you found that the defendant was, in some respects, some percentage liable, what damages and the dollar amount for the various types of damages will you assess? And so, medical damages or pain and suffering or mental anguish or lost wages and so forth. So how those questions are answered, same thing in a criminal case. The jury charge is presented to the jury. It's determined by the court and the parties working together to set up that jury charge. The local rules, as I talked about, Fort Bend County District Courts in general have local rules, same with the county courts at law, and then you go to the particular rules for each court. And then some of the statutes that are going to come into play. The family code, if you're dealing with a family law case, the family code is crucial, as important as the rules of civil procedure, because it governs more substantive issues in the family code. The estates code, say if you're dealing with a probate matter, the estates code is going to come into play, of course. And that's just kind of the tip of the iceberg. Those are some of the heavy hitters of things you're going to be dealing with and are going to be important to working on your own case. And we have all those things here in many formats. We have them in books, we have them on our legal databases and so forth. So they're readily accessible here in a variety of ways. So we talked about the courts of Fort Bend County last week a little bit, so I won't go into too much detail. We've got the district courts. These are the trial level courts here. There's 3 different trial levels in Texas. The district courts, the county courts at law, and the JP courts. And some of the specific information, that differentiates these courts, I've included in these slides, and I'll be sending you this as well. The JP courts have some of their own particular rules in the rules of civil procedure because they do things a little bit differently than the other courts, such as just one particular issue that is interesting. So if you have a JP court case, you have a small claims case, you brought a $5,000 case against a contractor who you didn't complete the job or didn't do a good job on your house or something, and then say you lose, and as the plaintiff, there's a defense verdict. And you say, well, I want to appeal that. The appeal out of justice court, the JP courts, is a total do-over, trial de novo. I guess that means new. And that's in the county court of law. So it kind of starts over in the county court of law, and they redo the whole case. As always, and I mentioned here, and this applies across the board, and contained within these rules of civil procedure and, some of the courts on particular rules, are deadlines. That there's always deadlines, and that's a big issue. It's for lawyers as well. The keeping track of all the deadlines of, say, your typical lawyer, might have dozens of cases on their docket that they deal with, and they might have a calendaring system that helps them keep up with all the various deadlines that are going to come into play. Generally, you're just going to be dealing with one case, but the deadlines are just as important, and can, in some respects, if you don't abide by them, can be pretty devastating at times. So just we'll skip through some of these things. This is just some general information about each of the courts. Like I said, go on each court's website. The information they have on there is very important. Some of the local rules, there are pro se pleadings, checklists, and so forth, rules of practice for each court, just to help you navigate as best as possible, dealing with that particular court. Especially now, because we're dealing with COVID-19, probably a word you're sick of hearing, and hopefully 6 months from now or a year from now, we'll put that in the rearview mirror. We'll never have to say that word again. But for the time being, it's a part of our lives, and it kind of affects everything we do in some respects. So it's no doubt affecting the courthouse here. Obviously, the courts aren't going to completely close, but they have modified their procedures quite a bit. I don't know, there might have been, I think there was a small jury pool brought in a couple weeks ago. Must have been to handle a case that just had to go to trial. But right now, there's trials aren't going on. But there are hearings and stuff going on. The show must go on in some respects, and some things can't wait. So there's other procedures now for conducting hearings via, like this application, Zoom, maybe getting things done via paperwork, via submission of affidavits and so forth instead of hearings. So each court, there's probably some consistency probably across the courts in general, but each court has its own procedures on how it's going to handle these things to try and get stuff done without in-person hearings. I think under certain circumstances, in-person hearings can go forward, but that's the exception more than the rule right now. Same thing, so the law library, we're partially open, partially closed, however you want to look at it. We're only allowed at this point to admit attorneys and county staff at this time. Pro se folks, please, you're welcome to come up here and come to our door, and we'll assist you, providing you forms or at least getting information from you such that we can send you those forms. To save yourself a trip, you're welcome to call us. I'll send you this email and this PowerPoint, and it'll have my contact information, but you'll see it here, our general number. And we have a general email that comes to myself and my boss, the law librarian Andrew, llpublic@fortbend.lib.tx.us. So we're looking to go to trial. We've talked about some of the steps and so forth and parts of leading up to trial. So, the initiation of the suit, the filing of the petition and the answer and issues associated with that. I'm not glossing over them, but, as we talked about in the PowerPoint and in the presentation last week, there's some things that you need to be aware of when you're responding to a lawsuit. The discovery and motion practice, hearings, trial, post-trial stuff. We talked about this is sort of a refresh of last week. You're filing a petition. Drafting the petition is governed by these particular rules. You got to identify the parties, the venue, where the county you're going to be, the jurisdiction of the court, the facts of the case, the causes of action you're bringing, such as negligence or breach of contracts, the damages you're claiming, whether it be lost wages or punitive damages, serving the other side. And there might be times you have to amend your petition or supplement it. So there's just these initial issues and we kind of talked about this last week, so I'm going to skip over most of this, but it's crucial stuff. Then the answer side of it, avoiding default judgment, you need to file a written answer. General denial is the most important part, but some things have to be verified. The denial has to be verified under oath, or you might have to make affirmative defenses. You might want to challenge the venue or the jurisdiction of the case. These are all things you need to consider before you file your answer and act appropriately. So reference the rules and so forth, and we have information on these issues as well. Let's see. So filing things. So, we have these things, the district clerk, the county clerk, the clerk of the JP court, they handle the paperwork for lawsuits. So you're filing pleadings, that petition is a pleading, the answer is a pleading, a motion is a pleading. Discovery is generally not filed. So when I send a request for production seeking documents from the other side, I do not file those with the court. You have to serve things on the other side formally. If I file a motion with the court, I got to serve a copy of that on the other side, out of fairness and notice. So these rules cover those things. Pro se parties are allowed to file paper-wise, but they're also allowed to e-file, as attorneys are allowed to, are required to, actually. So then you got to think about, the substance of your case. You're dealing with kind of all the mechanics of things, making sure you're doing the right paperwork and understanding rules and abiding by rules. But then you got to think about the actual substance of your case. I'm bringing a personal injury case. What do I got to do to show negligence on the other side? Or what do I got to do to, in a family law case, show that I should be, the sole managing conservator, or that I should receive child support, or that I am entitled to this disposition of property between me and my ex-spouse to be. The substantive law governing it. You've got all this procedural law. What's the substance of the law? And it applies to everything. So that's ultimately what we're going towards. What is that jury going to decide in that personal injury case or in that criminal case? A prosecutor, they got to prove their case beyond a reasonable doubt. What are the elements of you're charged with driving while intoxicated? What does the court have to, what does the prosecutors have to prove? And what are your defenses? So that's the substance of a case. That's the whole point of all of this. There's timelines of your case. So, and this can get kind of complicated. It can be governed by the rules of civil procedures, the scheduling orders of the courts, if they issue those, and the local rules of things. So this is kind of it's not so easy sometimes, especially Fort Bend County courts, in my view or experience, don't seem to issue what are called scheduling orders, where the court lays down some, this must be done by this date, this must be done by this date, this must be done by this date. You have to kind of figure it out for yourself, and that comes under Rule 190 of the Rules of Civil Procedure, the discovery control plans and the timing of things. So, there's 3 different levels of discovery control plan you can choose. 2 is the standard, 1 is sort of for simpler cases, and 3 is for complex cases. And so the discovery control plan that governs your case will in part determine the sort of timelines and deadlines of your case. So Rule 190 can be a bit difficult to navigate. And so, and what starts that timeline going is explained in Rule 190. Sometimes it has to do with when the first discovery is filed and so forth. And this all goes towards, when you have to, designate experts and how long the discovery period is going to last. How long can you take a deposition? A month before trial, the discovery period might end. You can't do any more discovery. So it's a really important issue. I know I'm kind of talking fast. We've only got limited time, but it's an important issue. We talked about discovery, gathering information from the other side. And this is governed by a lot of different rules, and there's a lot of different ways you can obtain this information. So I'll kind of, sort of talked about it, and I'm going to kind of skip through it to make sure we get through the presentation. But there's just a lot of different rules, the subpoenas, discovery limitations, requests for disclosures, Rule 194, expert witnesses, 195, interrogatories, sworn questions, questions you can ask that are required to be answered under oath. So there's a lot of different mechanisms for gathering this information in discovery. You can request a physical examination of someone, if it's an issue. You can get stuff from non-parties. I'm a party to a case. I want to get something from, a bank or some other person. There's mechanisms to do so. So let's kind of move on. Another big thing is obtaining records, and there's ways to do so and rules regarding that. For a newcomer to this, it's not particularly easy, but there's particular ways that you have to do it. There's expert witnesses. There's rules regarding identification of your fact and expert witnesses, who you have to identify, what information you have to give, and the deadlines for doing so. There's things called dispositive motions. So as you go through discovery and you're going through towards trial, you can seek to have a case dismissed prior to trial. That's what's called a dispositive motion. It's dispositive of the result of the case, such as summary judgment. We talked about that, I think, somewhat last week, or if you've attended my word class, we actually talked about that, where I can seek to have the court dismiss the other side's case. Say I'm the defendant, plaintiff's brought a negligence cause of action on a proper showing, I can try and get that case dismissed. It's a pretty high bar, though, to try and do so, because you're effectively taking away their right to trial. So you have to meet some pretty stringent standards. Like I said, other motions we've talked about, you might have to bring a motion for the court to determine something while the case is going on. There's hearings. So, sometimes you have to have hearings leading up to a trial of a case for the court to determine something. Those hearings, you're under oath. You have to give notice of the hearing. The information, the testimony is taken down by a court reporter. You can file a motion. The other side can file their response, and the court's going to determine it by issuing an order in general. You can skip hearings sometimes if you submit your paperwork by submission as opposed to a hearing. We got about 10 more minutes, so I think I'll be able to cover it. Like I said, there's settlement negotiations and settlement issues. You can try and resolve the case informally between the parties. You can have a mediation where you use a neutral sort of party to help you decide. It's usually an attorney. Arbitration comes into play sometimes. It can be required depending on it. You go rent a car from Hertz and you have a dispute about that rental. Tucked inside all that minutia paperwork that they give you when you rent the car is probably an arbitration clause. So it's about arbitration is definitely attached to a lot of different service issues. And so arbitration can be binding or non-binding. Anyway. Pretrial. So you're gone through the process and you might have to turn in some things. You're coming up on trial. Usually the court has its own procedures of what you need to turn in to the other side. Exhibit list, witness list, motions in limine and proposed jury charge, trial briefs on issues, motions to exclude. So motion in limine, that's kind of a thing where you're going to try and limit getting into certain issues unless you bring it up with the court first. Sort of a limiting issue, especially for explosive issues and so forth. I won't get into it too deeply, but if you are advancing on the trial, I can provide you information on those. The proposed jury charge, the court will want you likely to submit a proposed jury charge. Your proposed questions to the jury that will aid them in deciding the case. Motions to exclude, say you have a expert witness is being offered by the other side. You believe that witness is not qualified. There's ways you can seek to exclude that witness. That's just one example of some kind of pretrial motion. Then there's trial itself. You've all watched plenty of television shows that show trial. There's parts of a trial. There's voir dire, that's jury selection. There's rules governing that. There's opening statements by each side. Then the plaintiff presents their case. Then the defendant presents their case. Then the jury charge, the parties in the court will decide the composition of the jury charge that will be submitted. And there's mechanisms for the way you do this and what you have to do. The closing arguments then, and then the court jury goes in to deliberate, and then the delivery of the verdict. There's different kinds of motions that the parties can make during trial. Like I said, some of the key issues at trial, admission of evidence is a big thing. How do you do that? Authentication of records and things. Let me just give you one example, and I talk about it here in the PowerPoint. Photographs are a very important thing, or text messages. How do you get those things into evidence? How do you overcome maybe a hearsay objection, or how do you get that photograph, such that the jury can then look at it? There's a way you do it. There's some of them are very simple. A photograph is real simple. The mode in which you get a jury, get that admitted into evidence. Some things are a little more complicated, especially if the other side objects. Post-trial issues. Obviously, when the jury delivers its verdict and the court issues its judgment, which is the written, in writing sort of confirmation of the result of the case, then there's other issues come up. How do I collect on that judgment? I just won $20,000. Well, how do I then collect that money from the other side? Sometimes they just write you a check, but sometimes you might have to do something else to collect on that judgment. Or I lost and I want to do something about that. I can seek a new trial. I seek to modify or reform the judgment. I can file an appeal. There's an appellate timetable. There's deadlines, of course, there always is. When you lose, you are on the clock to do something about it. And if you don't, you probably lose the ability to challenge it, except for, there's the bill of review, which is sort of a last gasp effort. There's steps you can take, but you got generally about 30 days to do so. There's some other things that come into play. Rule 11 of the Rules of Civil Procedure allows the parties to make agreements between each other, and those things can be enforceable. They're basically contracts when you enter into those agreements. Oftentimes when cases are settled, you enter into a Rule 11 agreement to settle the case for X amount of dollars. And then if the other side wants to try to claw back on that, then you can seek to specifically enforce that. The family code, like I said, it comes into play, very important to a lot of cases that people are handling for themselves. Like I said, appeals, the JP courts, they appeal to the county court at law, and it's a total do-over. If you lose a county court at law or district court, you generally appeal to one of the regional courts of appeals here in Texas. Then ultimately you can go up the line to the Supreme Court of Texas or the Court of Criminal Appeals in Texas if that's a criminal case. Those are the highest state courts. There's different ways you can do things, notice of appeal. There's also some things called mandamus and interlocutory appeals that can happen kind of during a case, depending on the issue. Ultimately, cases can go up to the U.S. Supreme Court out of the states. The Supreme Court gets its docket both out of the federal court system and out of state court issues that bring about federal questions or constitutional issues. The Supreme Court docket, though, is pretty limited. It's not. They only take about 90 cases a year or something like that. So, like I said, there's federal court. We don't. The law library, we don't deal a lot with that because we're here in a state courthouse. We're dealing with county courts and district courts, and primarily what we're dealing with is state law. There are federal courts, obviously, and we have plenty of materials related to the federal system. The closest federal courthouse is in downtown Houston. There's plenty of them all over the state. A lot of the stuff is the same. The court structure is the same. It can't be that much variance, but there are obviously particulars to practicing in the federal system. Like I said, we have those materials and so forth, and if you need them. Like I said, we kind of got a lot of, I put some information here about federal courts to the extent it might be relevant to you. At least this will give you a little taste of that. Like I said, I kind of alluded to at the beginning of the case, this course is sort of to illuminate you as to the depth of information and at some level the depth of knowledge you'll need to acquire to fully handle your own case. Some cases are much simpler than others, but some are more complicated. And, you're going to have to at least gain some familiarity with the rules and procedures and so forth that will allow you to, handle your case as best as possible. How would you ever know, about all these different rules until you really have to? And so, now that you're involved in a case, you have to get up to speed on some of the things you didn't know before. Like I said, our contact information here is you're always welcome to email us or call us, and we'll do our best to assist you. We're here Monday through Friday, generally 8 to 5, not on the weekends. Like I said, we got a lot of good services. Some of them are temporarily on hold, but we will get back to normal at some point. But we've got a lot of good services here, copiers, meeting rooms, and fax machines, and just an extensive, excellent collection. I talk about the Fort Bend County and sort of the establishment of the law library. Now that we're here, we're given the resources, the financial resources in which to acquire the things that people need to work on their own legal matters, and for the lawyers here to utilize them. So we've got an excellent, we're not the biggest law library, but pound for pound, I put us up against anybody, and I think we've got a good staff here as well. Here's some pictures of the law library. Some of y'all are already familiar with it, have been here. We've got a nice space to work in, computers and meeting rooms and printers, tables, copiers, the books, So, like I said, I kind of put some examples of books here, but we don't have to belabor the point. We just got a lot of different stuff, a lot of excellent materials. These are materials I use to send to people all the time out of books such as the Texas Litigation Guide. These are the statute books, books that talk about, how to do things, how to conduct a trial, So, a lot of good resources here. Pattern jury charges, that's going to come into play if you're going to go to trial. Our computer databases, Westlaw and Lexis, are excellent. here's some links to some good websites, the clerks and so forth. Our website, our Facebook page, how to utilize the Fort Bend County website is on here. Information about finding an attorney, both the Indigent Defense Office, legal aid organizations, and other means of finding an attorney through the State Bar and the Fort Bend County Bar Association and Houston Law Referral Service. Yeah, anyway, I'm almost at my time. I know I took pretty much all the time in the presentation because it's pretty long, but please feel free to email me or call me with any questions or anything you need. Really appreciate y'all joining and having y'all in the class.